With the Indonesian government's move to issue a regulation in lieu of law to essentially replace the jobs creation law has come under heavy criticism. The move has been deemed as a disregard of the legal process, as the jobs creation law has been deemed unconstitutional and still needs to be revised by the House until November this year. But this newly issued regulation in lieu of law simply bypasses that process.
Ya biasa dalam setiap kebijakan, dalam setiap keluarnya sebuah regulasi ada pro dan kontra.
A day before the turn of the new year, Indonesia's President Joko Widodo issued the number 2 2022 government regulation in lieu of law, essentially replacing the controversial but still under review jobs creation law. With this move, the government has been criticized for disregarding the legal process, as the jobs creation law was previously deemed unconstitutional by the Constitutional Court. The court then ordered the House to revise the law, giving them until November 2023 to do so. But now the government's regulation in lieu of law bypasses this whole process. Indonesian constitutional law experts also criticized the way the regulation was issued just one day before New Year's Eve celebrations.
Karena Undang-Undang Cipta Kerja itu menurut putusan MK kan harus diperbaiki, bukan dikeluarkan Perpu sebagai produk hal ihwal kegentingan memaksa. Apalagi kalau kita lihat ya, waktu 2 tahun itu sudah mau habis. Jadi terang bagi saya Perpu ini adalah upaya untuk mencegah agar Undang-Undang Cipta Kerja tidak inkonstitusional secara permanen karena waktunya mau habis. Dan tidak juga terpenuhi ini hal ihwal kegentingan memaksa karena waktu untuk memperbaiki 2 tahun lalu kemudian pasal-pasalnya terlalu banyak ya. Tidak lumrah Perpu yang mendesak hal ihwal genting memaksa gitu ya, dibuat panjang-panjang hanya untuk kemudian menyelesaikan masalah sesaat.
Indonesia's coordinating Minister of Economy Erlangga Hartarto argued that the government's job creation emergency law was necessary and urgent to provide the government a foundation to face a potential global-wide scale slowdown and possible recession. However, constitutional law expert Bivitri Susanti said that this argument does not hold water.
Yang melalui Undang-Undang Cipta Kerja ini sebenarnya pemerintah ingin mengambil jalan instan, jalan pintas untuk mencapai pertumbuhan ekonomi. Nah, yang perlu dikritik dari yang namanya pertumbuhan ekonomi adalah apakah pertumbuhan itu merata atau tidak. Karena pertumbuhan ekonomi yang diangan-angankan oleh pemerintah itu pendekatannya memang istilahnya itu developmentalism, pembangunanisme. Karena pertumbuhan ekonomi yang semata-mata didasarkan pada statistik-statistik semacam GDP atau pendapatan domestik bruto, ya ukurannya ekspor impor begitu ya, tapi menyembunyikan apakah pertumbuhan itu sebenarnya merata atau tidak.
Furthermore, the government's jobs creation emergency law included many controversial changes. These include an article, specifically Article 79, Line 2, which states that companies can increase weekly working days from 5 to 6 days. Article 88C, Line 2 also states that governors can apply minimum wage levels. The phrase "can apply" means that provinces and cities are not legally required to implement minimum wages. Article 64 also gives companies the legal means to hire outsourced workers without any bounds. Numerous labor worker unions are now threatening that they will file a lawsuit against the government's job creation emergency law and bring it to the Constitutional Court, arguing that it disregards Indonesia's legal process and also arguing that it still contains many regulations that will harm the welfare of workers.